Yes, yes. You can come in.
Yeah, if Nitin can permit my colleague to share the slides.
Yes, you can continue. Yes, you can continue. Share.
My colleague Manjunath will be permitted to share the screen. Yeah, he has got it. Yeah, I was, before we logged off, I was dealing with the disqualifications. A candidate.
You have another system. There's echo.
No, there's echo.
You have another
echo. No, the other system is muted.
No, I think
because
muted. Because I don't have the other system should be completely muted.
Yeah, I think it's showing Nitin Basuraj and Basavaraj are unmuted.
Yeah, that's okay.
That is the echo. Because when I speak, there's no echo. When you are speaking, there's an echo.
Okay. Now?
Yeah, there's no echo now.
Okay. You can come. I think the problem is from my side. Sorry.
Yeah, no issues. Yeah, we were dealing, before we logged off, we were dealing with the disqualifications of a candidate. What are the qualifications to be a candidate, and what are the pointers which would disqualify you to be a candidate? So as the slide, I read out what are those disqualifications. To summarize, as per Section 8 of RP Act, if a person has been convicted of offences identified under Section 8, because Section 8 has a host of enactments which details out that if you are under UAPA or Prevention of Corruption Act, if you're convicted, then you are disqualified to be a candidate. Identified, and then for any offences sentence is not less than 2 years, then such person would be disqualified from contesting election for a period of 6 years. To take the most relevant example is of Mr. Rahul Gandhi, where because the conviction was for 2 years, he has been disqualified. That is an automatic disqualification if you are disqualified under Section 8. Unlike Section 8, there is Section 8A, which deals with the disqualification under corrupt practices. That is, after trial, the High Court holds that this person, a returned candidate's election is declared void because he had done certain corrupt activities. Unlike Section 8, it is not an automatic process. The power to disqualify, the High Court only declares the election to be void, but power to disqualify is vested with the President of the country. For that purpose, the Election Commission has to give a representation to the President along with the judgment of the High Court. Then the President would take a decision to disqualify the person, the maximum period being 6 years. So if it is a question of lodging, failure to lodge account of election expenses, Section 77 deals with this. It must be noted that 77 was amended in the year 1975 and Section 79B was brought in. 77 mandates that every candidate or his agent has to maintain an account of expenses incurred or authorized from the date of filing of the nomination till the date of the declaration of the result. Such expenses must be lodged with the district officer within 30 days from the date of election as per Section 78. If the candidate fails to lodge account of election expenses, Election Commission is vested with the power to disqualify such candidate for a period of 3 years. This is subject again to certain powers given to the Election Commission to reduce the period of 3 years. Now, coming to the challenge of elections. What are the grounds under which an election of a returned candidate can be challenged? A returned candidate was not qualified or disqualified, as we discussed in the previous slide. Corrupt practices has been committed by a returned candidate or his election agent, or by any other person with the consent of a written candidate or his election agent. The consent can be either, you will have to prove during trial. The consent either can be by the election agent or by the candidate or the election agent. And also that any nomination has been improperly rejected. Take an example, if Mr. A has filed nomination and that has been rejected by the returning officer, the remedy available to such a person is post the election. So he can challenge the election of the returned candidate on the ground that his election nomination was improperly rejected. The election results of the returned candidate has been affected due to improper acceptance of any nomination, corrupt practice, improper rejection of nomination. Now, Chapter 6 deals with disputes regarding elections, and Chapter 7 deals with corrupt practices and electoral offenses. So, written candidate was not qualified or disqualified, or was chosen to fill the seat. For instance, if a particular constituency was reserved for scheduled caste, and if the candidate did not belong to that caste, then having not been qualified to contest the election, it would be one of the ground to challenge the election of that written candidate. Now we have, while dealing with the previous slides, we have repeatedly, heard the term corrupt practices. Now, what are the corrupt practices under the Representation of People's Act? Section 23 of the Act deals with corrupt practices, which are bribery, undue influence, interference with a person's right to vote on the ground of religion, race, caste, community, language, etc., spreading enmity between different classes of society, publication of false statement in relation to personal character or conduct of a person in order to prejudice his candidature, that my competing, basically, making certain remarks against the opponent, which would prejudice his candidature, hiring any vehicle or transportation to and from the polling station of any person other than the candidate, his family, or his agent, and contravention of 77, which is again election expenditure. Then obtaining assistance of any persons provided under Section 123(7), which is the government servants. So if you have employed any bureaucrats during the election, that can also entail you, election to be challenged before the High Court. Then booth capturing. So summary of such corrupt practices is, I have just read out. So challenge to elections under the Representation of People Act. Now let us look at what is the definition of bribery, because most relevant for corrupt activity would be bribery and undue influence. I will just read out what is bribery as defined under Section 123(1). So 123(1) of the RP Act. Bribery, that is to say, any gift, offer, or promise by a candidate or his agent or by any other person with the consent of a candidate or his election agent of any gratification to any person whomsoever, with the object, directly or indirectly, of inducing a person to stand or not to stand, as or withdraw or not to withdraw from being a candidate at an election, or an elector to vote or not to, or refrain from voting at an election, or as a reward to a person for having stood or not stood, or for having withdrawn or not having withdrawn his candidature, or an elector for having voted or refrained from voting. The receipt of or agreement to receive any gratification, whether as a motive or reward, by a person for standing or not standing as, or withdrawing or not withdrawing from being a candidate, or by any person whomsoever, for himself or any other person, for voting or refraining from voting, or inducing or attempting to induce any elector to vote or refrain from voting, or any candidate to withdraw or not to withdraw his candidature. So bribery can be by a candidate or his agent, or by any other person with the consent of a candidate or his election agent. So explanation to 123 includes an election agent and a polling agent, any person who is held to have acted as an agent. So the bribery must have been done either by the candidate or by the election agent, polling agent, or any person who is held to have acted as an agent of the candidate, with the, and also that it was with the consent of the candidate. So explanation to 123, defines gratification, which means that for purpose of this clause, the term gratification is not restricted to pecuniary gratification or gratifications estimable in money, and it includes all forms of entertainment and all forms of employment for reward, but it does not include the payment of any expenses. So, as per the explanation, gratification is not restricted to pecuniary gratification or gratification which is estimable in money, and also includes all forms of entertainment and all forms of employment for reward. So, like now we see, generally we see in most of the elections, there are distribution of cookers, TV, sari as an inducement to vote or as an inducement not to vote for a particular candidate. In the recent judgment, which Mr. Basavaraj also mentioned, Mr. D.C. Gaurishankar's matter, the election of an MLA was held to be void as Medi Assist bonds were distributed to children of voters as an inducement to vote. It is also relevant to note that Section 171E of Indian Penal Code is pari materia with Section 123 of the RP Act, because 170 onwards, election offences start under the IPC. So 171E is pari materia with 123. Generally, what do we hear from the clients? If there is a FIR and a charge sheet is laid for offence under 171E, the client comes to us and says, no, I do not want to prosecute or contest this matter because it's a petty offense. Let me plead guilty. So by pleading guilty, what are the consequences? By pleading guilty, that person who has been now convicted under 171E automatically loses his voting right under Section 11A. A similar thing happened in the matter which we referred to in the of our own High Court. In that case, the counting agent had pleaded guilty for 171E. So that was one of the issue which was considered by our own High Court to come to the conclusion that even this counting agent was involved in corrupt practices, corrupt practices, as he had pleaded guilty under 171E. So we as lawyers will have to be cautious when we are dealing with election offences, even though those are considered as petty offences under IPC, because it may have ramifications if that particular candidate's election is challenged before the High Court. So as I mentioned, 11A would kick in if pleading guilty happens, and that person would be disqualified from voting for a period of 6 years, and that would take effect by operation of law immediately from the date of conviction. So undue influence is widely worded provision, subject to facts and circumstances of each case. If it is demonstrable that free exercise of electoral right was interfered with, it would be a ground for challenging the election. Now, what are the issues surrounding the challenge to election under the RP Act? Like, what are the pointers to be considered while challenging the election of a candidate? So now, which is the court which has jurisdiction to try an election under the Representation of People's Act? Election of a returned candidate can only be challenged by way of an election petition before a single judge of the jurisdictional High Court, as per Section 80 and 80A of the RP Act. The High Court in its discretion is empowered to try an election petition wholly or partly at a place other than the place of High Court. This becomes relevant when huge number of witnesses are sought to be examined to prove or disprove the case. There are instances wherein sitting was also held at places where most of the witnesses sought to be examined were residing. So the next issue would be who can file an election petition. We dealt with that earlier also when it came to the definition of an elector. Election petition can be filed by any candidate at the election in question or by an elector who was entitled to vote at the election to which the election petition relates to. The question of whether I might be an elector in a particular constituency, I might have not voted. So will I be entitled to lay a challenge before the High Court? Yes, you can. The question of whether the elector in question had voted at such an election or not is not material. You have to be an elector in that particular constituency. Therefore, a third party who is neither a candidate nor an elector of the constituency in question cannot maintain an election petition. So this has been dealt recently in 2021 in the case of Tej Bahadur versus Narendra Modi by our apex court, which details that 81 of the Act provides that an election petition may be represented by a elector or by any candidate at such election. The explanation to 81 provides that an elector means a person who was entitled to vote at the election to which the election petition relates. In this case, the election is to the Varanasi parliamentary seat. Obviously, the appellant is not an elector registered in the Varanasi constituency, since he is admittedly enrolled as an elector of Bhiwani, Haryana. Consequently, his locus thus depends entirely on the question whether he is a candidate or can claim to be a duly nominated candidate. 83 of the Act allows only an elector or a candidate to maintain an election petition. Similarly, impliedly that it bars any other person from filing an election petition. In this sense, election petition can also be said to be barred by 81, read with section 86(1) of the Act. Now, coming to the question of limitation. So, is there a period prescribed for filing an election petition? Section 81(1) of the Representation of People's Act deals with this question. The limitation prescribed for presenting an election petition is within 45 days from the date of election of the returned candidate, that is, from the date when the results are announced. So, as per law laid down by the Supreme Court in Hukum Dev Narayan Yadav and Lalit Naren Mishra, which is a 1974 judgment, and Lakshman Das Arora versus Ganesh Lal, which is a 1999 judgment, which says that Act is a special code providing a period of limitation for filing of an election petition. No period of for filing an election petition is prescribed under the Indian Limitation Act. The Act, insofar as it relates to presentation and trial of election dispute, is a complete code and a special law. So, similarly, in 2018, the Honorable Supreme Court in Suman Devi versus Manish Devi and others has held that Section 29(2) of the Limitation Act is not applicable to the RP Act, and therefore, insofar as the petition under Section 81 of that Act, there arises no question of condonation of delay under Section 5 of the Limitation Act. But now we had a situation of COVID. What happened to the benefit given by the Honorable Supreme Court in such a situation? That was dealt by the Honorable High Court of Kerala in case of Mani C. Kappan versus Sunny Joseph. There was an application filed under Order 7, Rule 11, seeking to dismiss the election petition as being barred by limitation, barred by law. But the Kerala High Court held that it was presented beyond the 45 days. But because of the applicability of the extension of limitation provided by the Supreme Court, the application under 711 was rejected and the election petition was entertained. Now, the third question is who all can be parties to the election petition and who are necessary parties to the election petition. So, 82 of the RP Act deals with who are necessary parties to the election petition. Firstly, and obviously, the returned candidate, if the relief sought is for declaring the election of a returned candidate as void. Secondly, if there is a prayer also made for declaration that the petitioner as duly elected, then all the contesting candidates have to be mandatorily made as parties to the petition. Any other candidate against whom allegation of any corrupt practices are made in the petition, then those parties candidates also should be arrayed as respondent. This would mean that a person other than a contesting candidate cannot be impleaded as a party. Other than the candidates who were in the foray of election, they cannot be impleaded as parties. So the next is, what are the reliefs you can seek before the High Court in an election petition? So Section 84 deals with the reliefs that can be claimed by the petitioner in an election petition. First is declaration that election of that written candidate is void, and the declaration that the petitioner himself or any other person as duly elected. So as denoted here, the petitioner, in addition to seeking for declaration of an election of the written candidate as void, can also seek for a declaration that he or any other person be declared duly elected. The option of seeking to declare any other person as duly elected is for the reason that the election petition can be presented by elector as well. And as elector cannot seek for a declaration that he himself be declared as duly elected, whereas the elector can seek for declaring another contesting candidate as duly elected. So these are the reliefs which can be sought before the High Court. Now, the contents of the election petition, because there are umpteen number of judgments on what should be the contents of an election petition. The content should first and foremost would be concise statement of material facts. So in case of allegation of corrupt practice, full particulars of such allegations, including name of the parties, individuals alleged to have committed such corrupt practice, the date and place of commission of each practice, that corrupt practice, verification of pleadings in the manner laid down in CPC, Form 25 affidavit in case of allegation of corrupt practice, disclosing which of the allegations are based on knowledge and information. So now, as a respondent, what are the primary contentions which are generally urged seeking dismissal, threshold dismissal of an election petition? Generally, application under Order 7, Rule 11 is filed, seeking dismissal of the election petition, not disclosing cause of action. Then Order 6, Rule 16 is filed, seeking to strike off certain portions of the pleadings as not being necessary. Primary thing would be the petition does not disclose material facts and particulars. The petition is not verified as per law. The affidavit accompanying the petition is defective. The petition does not disclose cause of action. So in deciding these primary issues of maintainability, substantial time is spent. So because it is strictly viewed, there is a time limit, there is a detail as to what all should go into the election petition. That too, if you are alleging corrupt practice, it is even more stricter. So what is material fact? Let's take an example. Person A distributed cash as an inducement. Factum of such distribution is a material fact. What are material particulars? Now, person Y, who is the uncle of person X, who is the candidate, on such and such a date, at such and such a time, and at such and such place, was distributing cash to such and such person, or can be electors also. Further, that person Y was doing so with the consent of the candidate, that is person X. So you will have to detail out if it is a case of cash, payment of cash, and being induced, an elector is being induced by payment of cash, then you will have to detail out when such inducement happened, what was the date, time, who were the people involved, was there a consent provided? At least there must be a pleading to the effect that the returned candidate was aware of such activity. And if you are able to relate that or identify a factual situation like registration of FIR, when it was raided or they were caught when such distribution happened, all those documents and narrations will have to be detailed out in the election petition. In the absence of material facts and particulars, petition would be dismissed. So now coming to the trial of the election petition, what is the procedural law applicable to trial of election petition? Subject to provisions of the Act and rules thereunder, Code of Civil Procedure and Evidence Act are applicable for trial of election petition. High Court of Karnataka also has rules for trial of election petitions. So non-compliance of Section 81 or 86 or 117 shall result in dismissal of the election petition. Can I amend my election petition if I have missed out certain particulars? So amendment is permissible at the discretion of the court only to the extent of amplifying or amending particulars of corrupt practices necessary for fair and effective trial. If you have missed out the major portion of when this corrupt activity was conducted, like the date or the person or the instance, then you cannot, by way of an amendment, bring it in the election petition. You can only amplify the facts which are already detailed in the petition. You can't, by way of an amendment, introduce any new particulars of corrupt practice not previously alleged in the petition. Then High Court, can the High Court refuse to examine witnesses? Yes, High Court can refuse to examine witnesses in case such examination is on frivolous grounds or with a view to delay the procedure. Trial of election petition to be continued, the law says it has to be continued from day to day until its conclusion, unless adjournment beyond the following day is necessary. Election petition is to be tried expeditiously and endeavor shall be made to conclude the trial within 6 months. So 6 months period has not been followed. At least we have not come across any of the judgments which have closed an election petition within 6 months. Generally, the election petitions take longer time because of the initial preliminary objections, which will have to be dealt with the election tribunal. And also that election tribunal, the learned single judge would also have certain other matters. So this matter also would take some time given the roster and certain other contingencies. So now, what are the orders which can be passed in an election petition? The High Court can dismiss your election petition, or holding that either if it was for corrupt practices, you have not proved, or if it was for counting, then the counting was correct, the validity of voting will be upheld. And apart to seeking for declaration of the written candidate's election to be void, if you have sought for declaration that you be declared, the petitioner be declared as a candidate, then declaration of the that petitioner or any other candidate to have been duly elected, then record the name of all persons who have been proved at the trial to have been guilty of corrupt practices. So this is an entire procedure which the High Court would undertake if you have alleged corrupt activities being undertaken by the agents and other persons with the consent of the election returned candidate. If it is candidate, then this procedure under section 99 will not be undertaken by the Honorable High Court. If you are alleging that the election agents and the other persons with the consent of the election returned candidate have conducted the corrupt practices, then they would be named. They will get a right to put up their defense. They can lead evidence to defend themselves. They can seek for cross-examination of the witnesses who have already been whose evidence has already been recorded by the High Court, who would have named these particular individuals in their evidence. So that would again relatable to section 11A. If that person is also named finally by the High Court, then the consequences of 11A and 8A would follow. And again, the 8A procedure, the president will have to undertake, holding disqualification to a particular, whether it is to be 6 years or less than 6 years. Now, the High Court passes an order under 98, 99, and 101. So what is the effect of the order of the High Court? So the High Court, upon passing the order, has to intimate the substance of the decision to Election Commission, the Speaker or Chairman, if the Assembly is still in session, or of the state legislature concerned, publication of the order in the Gazette of India or in the official Gazette of the state concerned, subject to stay. Order of the High Court shall take effect as soon as it is pronounced. There is a provision under 116B which grants power to the High Court to stay its own order until an appeal under 116A is preferred to the Supreme Court. So if there is no stay by the High Court, then it automatically takes effect immediately. And the acts and proceedings in which returned candidate had participated prior to the order shall not be invalidated. And disqualification under section 8A and 11A is not an automatic disqualification, but it will take effect according to the procedure laid down under the as per 8A and 11A. So relevant considerations for the trial of election petitions. So if you do not have, if there is a lack of material facts and particulars, it is fatal to the election petition. So election petition has to be drafted in greater detail with great caution. As we know, you have a limited window of 45 days. So you will have to gather every information and understand what is the requirement under law, what are the specific details which are mandatorily required to be given in an election petition. That has to be detailed out in the election petition. And allegation anterior to nomination of a candidate are not relevant. I am stating this because the candidate, as per the definition under 79B, the person becomes a candidate only upon his nomination being accepted. So I am a candidate. My nomination is accepted on, let's say, 10th of June. But I have done certain activities prior to that. Can that be taken into account by the High Court while dealing with? And can he be convicted based on those instances, activities which were done either by him or by his agents prior to he becoming a candidate? The answer is no. It can be considered to complete the chain of events, but only instances which were done prior to he becoming a nomination, conviction cannot happen, or the disqualification or the declaration under the RP Act cannot come. You have to prove that the corrupt activities were done after the returned candidate became a candidate. So you have a small window of say 2 to 3 weeks to prove that within these 3 weeks he did or his agents did, with the consent of the election returned candidate, these corrupt activities. So all those prior activities of distribution of sari or TV, if it is not post he becoming a candidate, are of no relevance, except that it completes a chain of events. That's it. And if it is instituted under the on the ground of corrupt practices, it is a quasi-criminal proceeding, and the allegations will have to be proved beyond reasonable doubt. And affidavit can I file affidavit in lieu of examination? Should I examine the party, putting him in witness box? No, you can file affidavit in lieu of examination. It is permissible under the election petition. I'm bringing this up because there are a few judgments which have taken different views, but finally the Supreme Court judgment says that you can lead evidence by way of filing an affidavit. So consent should, all of us know, there can be a lot of instances. I cannot even identify instances where I can directly quote that this candidate did the corrupt activity. So the consent of the candidate. So I cannot get evidence to show that consent was given by the written candidate to this person X, who's an election agent or an agent, a polling agent, or any other person. So consent will always have to be inferred from the circumstances. So how would you prove circumstances? You will have to examine witnesses by that who had received such inducement. You will have to lead evidence to that effect. And other issue is you don't have to name each of your witnesses in the election petition. So even the High Court, our own High Court rules sets the procedure. Post framing of issues, you will have to give the list of witnesses. So, if you need to take summons, then you will have to seek permission of the court to issuance of summons. And apart to the candidate, as I mentioned, the Section 99 procedures, other persons can also be named in the judgment as having committed corrupt practices along with the candidate, and consequences of 8A and 11A shall follow. So this is it about the challenges which can be levied. Thank you.
Yes.
Yes, I've completed. Thank you. I thank KSBC Law Academy for giving me this opportunity.
The questions can be asked. We will be logging out in another 2 minutes and we will reassemble. Anyway, till then, questions can be asked. Now, Nalina, what I was thinking is, there are at least 4 types of disqualification. Number 1, disqualification at the stage of Section 36 of the RP Act at the time of scrutiny. The
Yes.
disqualification is referable to Article 191 of the Constitution, where he holds an office of profit or other disqualification, then the returning officer has the power to reject the nomination paper. That is one set of rejection. Second one is, if that person is returned as a successful candidate, then the election petition on any of the grounds his election can be challenged and can be set aside by the High Court. That is second. Third one is, suppose after the election, if he suffers a disqualification like office of profit or any other thing, then the governor can disqualify in consultation with the election commission. That is one. And fourth one is the disqualification referable to Schedule 10 of the Constitution, that is anti-defection scenario, that where the speaker will disqualify the elected candidate. And the last one, the conviction of that person in a criminal court, and the disqualification there also is automatic. So there are 5 types of disqualification which a candidate will suffer apart from along with the election petition under the Representation of People section 100. So at every stage, the election of a candidate is checked. That is before the election, that is at the time of scrutiny of nomination paper. Then after the election, if he suffers from any disqualification, the governor will disqualify. Then if there is an office of profit, etc., then the governor will certainly take the call. If there is a defection, the speaker will take the call. And if there is a criminal prosecution and which ends in a conviction, then the disqualification is automatic. I'll open the channel for questions. So you can unmute yourself and ask the questions. There's some messages if we can read. What is the punishment provision for the common people who ask bribe to vote? Voter, I think there is no disqualification for the voter.
Yeah, there is unless you are naming that person under section 99. No, if you're a voter and you're asking for money to vote, then there is nothing which governs which is governed under the RP Act.
Under the Prevention of Corruption Act, even the bribe giver is sometimes unless
taker. Here the voter will be the bribe taker.
Unless it is it's a trap, even the person who instigates the person to take the bribe is also responsible under the Prevention of Corruption Act. But here such a provision is not applicable to the Representation of People Act. And if you openly ask for bribe, who can file election complaint? I'm confused. Please explain again. Any voter or the person who's defeated? Who can file the election petition before the High Court?
It's an elector or the defeated candidate. So those are the two. I think that it said complaint. I don't know. Did it a person asking complaint before the election commission or the?
I think he was referring to election petition. He loosely uses the word complaint. So it's the election petition. I think the defeated candidate and the voter, any voter from that constituency, right?
Yes. The elector can make a challenge.
No, I have received a message. Whatever this guarantee card of the Congress political party, and also the QR code. See, one is a guarantee card is part of the election manifesto. That is one. The second one is the so-called QR code. In your case, where you succeeded, Mr. Gauri Shankar had planned this health insurance policies which were taken earlier to election and which were effective after the election is over. Now, in this case, some QR code cards were distributed where it can be used in the provision stores and other places against food and other articles. So guarantee card is part of election manifesto, and QR code is, I think it's an outright bribery which the candidates may or may not own it. Your views, Nalina?
See, if we are looking at the offers which are being made, so we'll have to take into consideration who made this offer or who gave you these assurances. Was it the leaders of the party, or did the candidate himself held out to the electorate saying that if you vote for me, I will give you this particular benefit? So if it is an assurance by a leader of a political party, not by the candidate, then it is not considered as a corrupt practice, because the undue influence or bribery cannot be relatable to the leader of a particular party. So if it is the candidate himself, then you can make a challenge.
Any other questions? You can unmute yourself and ask the questions. What is your view on this freebies? Of course, the matter is pending in Supreme Court. Diverting taxpayers' money. Of course, it started in New Delhi. Diverting taxpayers' money to give free. For example, if instead of giving the money, if certain schemes are formulated, employments are generated, and the payments are made indirectly, indirectly, that's okay. But direct payment from out of the state exchequer in the form of freebies. Your views, Nalina?
See, it is also a form of inducement, right? That is an undue influence. You may call it a public policy at a later point of time, but at that time of going to election, you are giving them those assurances based on which I am casting my vote. So you may term it as the government is providing those, though as you said, it's a taxpayer's money. It would definitely be a bribery, according to me. It should fall within that.
Any other questions?
Yes, I have a question.
Kavita, you can
you please
start the video. Yeah. Yes.
Can you please elaborate on the consequences of disqualification? Disqualification after conviction and disqualification after the verdict in an election petition?
Yeah, that is a question, I think, which was discussed in greater detail when Mr. Rahul Gandhi's conviction happened. That was a automatic conviction under Section 8 of the RP Act, because if you are convicted for a period of 2 years, then you would automatically lose your seat. Unlike under Section 8A. So Section 8A would come into picture only if after trial the High Court holds a person to have been involved in corrupt practices. Then the High Court has the power to declare the election as void. That is all. The disqualification is in the domain of the president. The disqualification would be by the president, which the election commission has to take it. So it is, people presume that the moment the High Court declares the election as void, then there is an automatic disqualification. It is not so, unlike in Section 8.
Thank you. Thank you.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ ಕೆಎಸ್ ಅಕಾಡೆಮಿ ವತಿಯಿಂದ ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಬೆಳಕು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಿದಂತ ಶ್ರೀಮತಿ ನಳಿನಾ ಮಾಯೇಗೌಡ ಅವರಿಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕೆಎಸ್ಬಿಸಿ ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸಿದ್ದೇನೆ. ಮತ್ತೊಮ್ಮೆ ಬೆಳಕು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ನಾವೆಲ್ಲರೂ ಮತ್ತೆ ಭೇಟಿಯಾಗೋಣ. ಅಲ್ಲಿವರೆಗೂ ಧನ್ಯವಾದಗಳು. ಶುಭ ಸಂಜೆ.
Thank you.
I had a quick question.